Hi, Lords. Good morning.
Good morning.
I've largely covered, having looked at my notes overnight, most of what I wanted to say. So I'll personally only be a few moments.
Yes.
Mr. Willen is going to address your Lordships on case management. Of course, that's important. But I won't say anything more on that. I do want to do two things. I want to summarise very briefly our case on global claim. And I will reiterate that our case remains, as we set it out in our skeleton argument, that's set out in paragraphs 41 to 85. Don't invite your Lordships to turn it up unless your Lordships wish to do so.
Yes, please.
But then, I secondly just want to say a few words about material contribution before handing over to Mr. Willen. My Lord, in the chair to see. So, I'm sorry, my Lord. I thought my Lord was about to.
Do you want to mention timing?
Yes.
Thank you, my Lords. Let me just then summarise very, very quickly our case on the global claim issue. First, we say that the claimant's claims are inadequately pleaded because they have failed to specify. It's actually inter alia because they failed to specify the causal link between the oil spills they rely on and the relevant part of their loss, i.e. they failed to advance a positive case of causation in respect of oil spills, and that's part of the essential facts that must be pleaded under CPR 16.41a and confirmed by Practice Direction 19b, para 14.1 in the GLO context. That's the first point. Secondly, instead, the claimants allege that the defendants are legally responsible for all their loss on the basis that the defendants are legally responsible for all of the events which caused their loss. That's what's known as a global claim, which is, we respectfully submit, just a convenient label for a claim where a claimant claims in respect of multiple events but doesn't plead the case on causation individually in respect of each event. It might be helpful just to look at two sentences in one judgment your Lordships haven't seen yet, which is the judgment of Mr. Justice Byrne in the Australian case of John Howland, which is found in Authorities Volume 4.
Just before we do that,
Yes, yes.
I go back to something that was raised yesterday.
Yes.
You are not saying, are you, that the whole litigation, the whole Bille individual litigation, is a single global claim?
Well, it's not us.
Or are you?
No. First of all, we're saying it's the individual claims by the individual claimants, which are global claims.
So you're saying that this claim form includes within it 2,000 global claims?
We are saying, just to be clear, and I don't want to avoid my Lord's question, but we are saying each claimant has brought a claim which, properly understood, is being brought as a global claim because they are relying on a number of events without specifying what the loss is flowing from each of the events that they rely on. That's what the label means, and therefore that's what they're bringing. And I'll just come back to this, and Mrs. Justice May made the point, I think Mrs. Justice O'Farrell did as well, though the claimants don't want to characterise it that way, that is objectively what it is. I'll take my Lords back to that.
But what each one is?
Yes.
Each one is a global claim, you say, but isn't that trespassing on a big question of law yet to be decided, which is whether a claimant says, my fishing ground was damaged by oil spills.
Yes.
I say they were caused by Shell.
Yes.
I can't tell you which spill.
Yes.
And Shell may say, this may have been third-party interference, illegal bunkering, sabotage,
Yes.
Chevron.
Yes.
none of that.
Yes.
The claimants say, well, that's all very interesting, but all we have to show is that Shell did something which made a material contribution. That's a big issue, but it's not a case management issue.
Well, that's the material contribution point. And just sort of what I wanted to say about that, maybe it's convenient just to say it now. Firstly, it is a controversial area whether or not material contribution, as opposed to but for or extended but for, is the correct causation test.
Yes.
And we respectfully agree with the observation from the court yesterday. This is not really the case to decide that, and we're not inviting the court to decide whether it is or isn't an adequate test for causation. That's one point. The second point, which in a sense is the more significant point, is the way that it was approached below rightly is that actually it doesn't answer the question. Our concern is that the claimants haven't identified which are the events which are said to give rise to our responsibility. And it doesn't matter for that purposes whether it's on a but-for basis, an extended but-for basis, or a material contribution basis. We still don't know what the events are that they say caused their individual losses.
And you have to have that, or the best identification of that, before you are forced to come to the table and defend the position.
Yes, and whether it comes to the table to defend it is the right expression.
To come to court.
Yes, and we're back to the question of it has to be provided.
But that's the critical thing, is that you must have, somehow or other, you must have what, if one were to look back at it retrospectively, gives you a fair opportunity to defend the claim that's made against you.
Yes.
And if that is achieved or achievable, then the case can go forward.
Well, that's really into the case management issue, because that comes to how do you do that, and a little bit when do you do that.
I'm talking at a very
high level
of abstraction.
My Lord, yes, absolutely right. Yes, my Lord, that is it. We have a right, and the way that things work in this court, in this country, is you put your case forward, you state the essential facts on which you rely. That's what the defendant then knows he has to investigate, respond to. That's the agenda for trial. All these things we looked at from Mrs. Justice Cockrell and others. Very familiar stuff, but worth doing in any event. And that's how you can then have a fair trial, because you know where you're heading and what the target is. My Lord, yes.
Yes, right. Sorry, you were going to.
I just want to show much
to an authority.
Yes, please, my lords. It's Authority Volume 4, Tab 28. My lords, it's a decision of Mr. Justice.
Could I have page number?
I'm so sorry. I'm running ahead of you. Tab 28, page 1165.
Thank you.
It's a decision called John Holland Construction and Caverna Brown. It's Mr. Justice Byrne in the Australian courts, and I'll come back to the relevance of Australia, as it were, for this. But it's a very helpful summary. Paragraphs 14 to 15, which is at page 1173. It's a useful description of global claim and a bit about the logic of global claim. If my lords would read paragraphs 14 and 15, explaining what a global claim is, and particularly the first sentence, the claimant doesn't seek to attribute any specific loss to a specific breach of contract, but is content to allege a composite loss as a result of all of the breaches alleged, or presumably as a result of such breaches as are ultimately proved. And such claim has been held to be permissible in the case where it's impractical to disentangle that part of the loss which is attributable to each head of claim, and the situation has not been brought about by delay or other conduct of the claimant. As I said yesterday, it's permissible because you're still setting out the essential facts of the case. It's just you're doing it by saying the essential facts are A or B or C, and those are all the responsibility of the defendant. And then there's a slight extension which does take one into the construction world, which is paragraph 15, which is using the expression now slightly different, which is a total cost claim. My Lord, see that at paragraph 15. And that's, in its simplest manifestation, a contractor alleges against the proprietor a number of breaches and quantifies its global loss as the actual cost of the work as compared with its expected cost. That's adding a different issue, an additional issue to it, which we're not really concerned with. But the important point I want to just draw attention to is what is then said in the final paragraph on that page. The logical consequence implicit in this is that the proprietor's breaches caused that extra cost or cost overrun. The implication is valid only so long as, and to the extent that, the three propositions are proved, and further stated one is accepted, the proprietor's breaches represent the only causally significant factor responsible for the difference between the expected cost and the overrun. In other words, as I was submitting yesterday, if it turns out it's not A or B or C, but D, or that the defendant is not responsible for A or B or C, that's why the claim fails, because you put it forward on that global cost, global basis, right? Composite basis.
Thank you.
Well, that's so there's a convenient description of the principles, and I just wanted to note, we say this in our skeleton argument at paragraph 46, and I draw attention to the cases in the footnote at paragraph 47, which is, sorry, the authority cited at footnote 57. We say these principles have been accepted by not just by the Scottish courts and the Australian courts, but also by the English courts, and we set out the cases in footnote 57, and they obviously include Mr. Justice Aikenhead's decision. Yes, thank you, my Lord. Then the next point, third point, on the summary, the claimant chooses how to plead its case. It's for the claimant to choose how to plead its case, but it's then for the court to decide what that amounts to. And that's what Mrs. Justice O'Farrell made, the point she made at the CMC in May 2022. I don't need to ask my Lord's alternative, I'll give the reference. Supplemental Bundle 1, tab 8, page 73, which is internal page 64, lines 10 to 18. The court is not specifying, she said, what words the claimants must use.
Was that S1 873?
SB1 873, yes.
Thank you.
So the claimant specifies, but then it's for the court to work out what the effect of that is. Next point in the summary, a global claim is therefore permissible, but subject to its own internal logic, i.e. that the defendants must be found to be legally responsible for all of the events said to have caused the claimant's alleged loss. And that was the finding made by Mrs. Justice O'Farrell in April 2022, but she ordered the claimants provide better particulars of causation in order to avoid the global claim difficulties. And the reference to that is paragraph 74 of her judgment. And the reference is SB1, tab 4, page 46. And paragraph 74 of her judgment is where she sets out all the things which she believed and ordered that should be provided. Now that was her order. The claimants didn't provide those particulars. In fact, if I can put it this way, they doubled down on what they were saying by serving instead voluntary further particulars which confirmed that all bar the 5 were relying on all of the oil spills. It didn't narrow it down at all, it did the opposite. It did, as I slightly colloquially put it, they doubled down on their proposition that they relied on everything with those particulars.
I'm just going to stay quiet for the moment.
My Lord, next point, Mrs. Justice May was therefore right to find that the claimants were still advancing global claims in November 2023, and that's what she said at paragraph 44 of her judgment. But she made it very, very clear that the claimants could apply to replead their case, to plead causation, I'm going to use the word properly, or to rely on the Aikenhead exception, if I may use that epithet. And that's set out in paragraphs 44 to 45 of the November 2023 judgment, Core Bundle 1, tab 4, page 47. So although the eternal logic works that way, there are these clear escape routes. One of them is to replead, which is what we all hoped that the claimants would do.
In all 2,000 cases.
Well, except they've got a single claim form, so they can do it.
Well, it might be in a schedule, but I think your case has been throughout that each claim has to be pleaded.
Yes, I'm not. Yes. Yes, I mean, they've chosen not to group the claimants themselves. They could have done, I suppose. I'm not going to get into that. They could have said, these claimants all claim in relation to this. But that's perhaps more the case management point, which I leave to Mr. Willan to develop. But yes. But anyway, she made it clear that they could replead it or rely on what I'm terming, I hope not disrespectfully, the Aikenhead exception.
Right.
Next point in the summary. So therefore, Mrs. Justice May was entitled to make the global claim finding as a matter of law. And the two arguments which we understand the claimants put forward against that don't withstand scrutiny. And I'll identify what they are. First, the proposition that the global claim is not a concept, is a concept confined to the construction context. It's not, in our respectful submission, as the courts below found, and Mr. Justice Waxman also said in the Alame case. It's just an application of basic pleading requirements, which is what's said at paragraph 42 of the November 2023 judgment. That's Core Bundle 1, tab 4, page 46. And secondly, those requirements are not abrogated in the GLO context. And that's paragraph 62 to 63 of Mrs. Justice O'Farrell's judgment in April 2022, SB1, tab 4, page 42 to 43. So that's the first argument that's raised, as we understand it. The second argument, we say the global claim does not subvert substantive principles of causation. That's the argument that we develop and put before the court.
Well, you would agree with that, couldn't you? Normal principles of causation apply.
Yes.
Full stop.
Yes.
Whatever label you attach.
Yes, and the concept of global claim, we say, does not subvert that.
Yep.
And on that...
I misheard. Your submission is it doesn't subvert normal principles.
That's right.
My mistake.
That's right. And then I just want to deal with and I've already indicated what I will say about it. On that last point, we respectfully agree with the observations from this court yesterday that material contribution as an exception or a qualification on causation principles is not something to get into on this appeal. And that is for three reasons. First, as my Lord Justice Mayles noted yesterday, it's common ground that causation is a matter of Nigerian law in these proceedings. Secondly, as we set out in paragraph 63 of our skeleton argument, the global claim, and I've said this several times, is a pleading issue. Whichever is the correct test of causation as a matter of substantive law, the current pleading still begs the question, which spill caused which part of your loss, whether you're saying but for, extended but for, or material contribution is the test of causation. It still doesn't say which of the pleadings did that. And this is the point that Mrs. Justice May made in our respectful submission rightly in paragraphs 38 and 43 of her November 2023 judgment. And my Lords will recall that passage when she said you're still not saying what the event did, and that's the references Core Bundle 1, tab 4, pages 44 to 45. And the third point, as my Lord Justice Smith pointed out, is the question of whether and when a material contribution will suffice to establish causation is a difficult and developing area of law, under English law, and the sort of point that it would be undesirable for this court to seek to determine obiter in a case, particularly in a case which is not relying on, which is not turning on English law. But we submit and I develop all this if necessary, but I'm taking the hint not to do that, if there's nothing in the authorities to support Miss Day's case that there's some special rule of causation which applies in environmental cases.
I don't think we have it in mind at the moment to write a thesis on the law of material contribution.
Professor Stapleton will write a third one if you do.
That is certainly true.
My lord, but that's what we respectfully submit that your lordships are right to take that position.
It's a very interesting question, but not one for this week.
Yes. Interesting and important indeed. And as my lord's questions to Miss Day revealed yesterday, everything is going to depend on the particular facts, what contribution different parties made, whether another source of pollution was itself sufficient to cause the harm, whether the harm caused, to use the expression that my Lord Justice Stuart-Smith explained in Holmes' case, whether the harm is regarded as divisible or indivisible, whether there was already pre-existing pollution, such that any further spill caused no additional loss. Not something that could be assessed in the abstract in any event without a proper pleading. So that's an additional reason, really, not to write the thesis on this occasion.
That suggests to me, subject, of course, to whatever is the outcome of this appeal, that it may be impractical and perhaps even impossible to address these questions at a preliminary issues trial on Nigerian law in January or February before the facts are known, because there's a whole permutation of possible facts which may arise about different causes playing a part in losses suffered by an individual claimant, and the extent to which it is or isn't possible to disentangle those different causes, which means that it could be quite difficult to answer such questions in the abstract.
Well, my lord may well, of course, be right, and when we get
again, that's not really for today, but it's something which, as I say, depending on the outcome of the appeal, the parties may need to think about.
Yes, my lord. As I say, my lord may well be right. I'm reluctant to discourage any attempt to answer those questions, because the one thing that is sort of the judge believed, and I think it's common ground between the parties, if we can get answers to those questions, it is going to assist getting this case moving forward very much.
Well, so there are some questions of Nigerian law which it would be very helpful to have an answer.
Yes, but my lord is of course right. It will depend upon what facts are presented, and I take my lord's point. My lord, those are the points that I wanted to make, and I'm going to hand over to Mr. Willen unless there's anything your lordships want to put to me.
I don't think so. Thank you very much. Mr. Willens, I meant to ask, when Lord Goldsmith rose to his feet, he said he would be a few minutes. I meant to ask when you, plural, expected to finish.
My lord, I expect to be finished before lunch.
Good.
Which hopefully will allow Ms Day sufficient time to reply and for you to have the opportunity you sought to discuss matters amongst yourselves.
Yes, thank you.
So, my lord, I'm going to address what we say, or our proposals, in the event that you find that either grounds 1 or grounds 2 succeed. So you say either this isn't a global claim, or another possibility that if the case were taken to trial as currently pleaded, it would be a global claim, but that nonetheless it's not right to manage it presently as a global claim, and instead it can be managed to convert it into the sort of claim the claimants say they want to bring, if I can put it that way.
Well, you're using the singular, that if this is a global claim.
Global claims, it's not a singular. It is each claimant's global claim. Nonetheless, each claimant at present pleads the same global claim in the sense that they all rely on the same entire universe of spills.
They adopt the same approach.
They adopt the same approach. They adopt the same general paragraph. We rely on the 2011 to 2013 spills, and they adopt the same VPOCs.
Can I just ask you, for my note and following, obviously we'll have a transcript of what you say, but you're floating free a bit at the moment, aren't you? Your proposals for what we should do in the event that we're against you do not form part of your current skeleton. We haven't got them in writing at the moment.
You do to this extent. In our
Not
skeleton,
complaining.
no. In our skeleton, we say, for instance, we say you shouldn't order standard disclosure, and that's one of the points I'm going to be making. And we say you should order particularisation of the claimant.
I can't turn to your skeleton and follow where you are.
Not in a single paragraph.
Okay.
Not in a single paragraph.
Right. So if you find, if we find
Either not global claims or not to be managed as global claims.
There's a third option, which is to be managed so as to convert them from what you call global claims into a claim which you would accept, well, whether you accept it or not, is fair to you in giving you an opportunity to meet the claims you have to meet.
Yes, although I would say that is my second option, in that if you say it's not to be managed as global claims, the only way forward really is to manage it so as to bring it in line with the case that the claimants say they want to bring. There's no real alternative. The only other alternative is a strikeout. And
in case you say you want to meet.
and the case we've said since we appeared in front of Mrs. Justice O'Farrell that we want to meet. It's no secret that our position has always been, tell us which spills you're complaining about, and we'll fight you on them. What we don't like is you are very bad people, and you have to fight all of that without any greater detail, which is what we say the case at present amounts to. Now, of course, what we say is the fact that you reach that conclusion doesn't mean that suddenly all the problems with the pleading fall away and that we just proceed, as Ms. Day suggests, straight into standard disclosure, which is the next step on her proposal. Because you still have to address, in our submission, the fact that the case is not adequately pleaded and not in a state that we could fairly currently respond to. And that really then brings me to the question that I think your lordships were asking at the end of yesterday, which is how do we break the deadlock? Or how do we address, if we're right, our concern about particularisation in circumstances where there's never going to be a trial of all 2,000 claims simultaneously? And that's what I'm going to try and address. Just before I do that, it strikes me that there are really three things that this court could do, if I'm not being too presumptuous to suggest it. The first is that you could simply say, we set aside the global claim declarations and we remit the case to the managing judge. And so she can decide what the solution to the problem is. The only thing this court having told her is that global claims is not the solution. That's one option.
Well, when you say global claim declarations, the second and maybe even more contentious declaration was the claimant's pleaded case precludes case management of this litigation being organised by reference to the selection of the claim.
And I accept that would fall away if you are against us on global claims.
Thank you.
Because if it's not going to be taken forward as global claims, we accept at some point there is going to have to be a lead claims trial because there's not going to be a 2,000 claims trial. The second option at the other extreme would be for you to re-exercise the case management discretion afresh and to produce a 50-paragraph order, effectively having conducted a CMC. Now, we invite you not to do that for a number of reasons. First, there's not going to be time. Second, I very much doubt it's going to be worthy of this court's time to effectively conduct a CMC. Third, frankly, it's better for the managing judge who's going to be the one who has to try these things to take the detailed decisions. And fourth, once we know the shape of the case, I suspect that there will be a decent possibility of some degree of agreement being reached. Once we know what shape of structure we're looking at, things like dates really ought to be capable of being agreed. So we would urge you not to go down that road, which leaves the third option and the middle road, which perhaps always sounds most attractive, which is for your lordships to give the broad shape of how a case like this, or indeed how this case, can be taken forward, whilst leaving the detail of the directions for the managing judge. That's the course we would invite you to take. You are, in our submission, well placed to resolve the issues of principle which divide the parties. And it's right to say that there are some points on which the judge has given views or reached decisions, for instance, standard disclosure, where we say she has reached conclusions independently of her finding on global claims. And therefore, it probably is most appropriate for your lordships to say whether she's right or wrong about those points. There's also a wider public benefit that this court's guidance on how one moves forward in a case of this complexity would potentially be of use to other courts who have to decide it rather than it being developed at first instance level. So we do invite you to set out the shape of the way forward, but without delving into the detail of perhaps how that will be done. If you're not persuaded by that, then we would say the only sensible course is for you simply to set aside the declarations and remit. So let me then take you to what our proposal is in the form of a 5-point plan as to the shape of trial. And point 1, we invite you to decide that it would not be appropriate to order standard disclosure across the entire action, including fault and other issues of liability, at this stage, given the inadequately particularised form of the pleadings. And we say the judge was right to say standard disclosure at this stage is inappropriate. Second...
Can I just ask, your 5-point plan, has that been shared with the other side, or are they hearing it for the first time?
They are hearing it for the first time. That point is definitely in our skeleton. And we have said in our skeleton,
Whatever else.
whatever happens,
I follow that, but just the 5-point plan is...
The 5-point plan, I think 3 of the points are in our skeleton and 2 of them are new.
Yep.
And I
Would you like to tell us what the 5 points are before you develop any of them?
I will. I will.
So that was number 1.
Second, we invite you to find that the claimants should receive any further specific disclosure which they require for the limited purpose of identifying the spills on which they rely and pleading their case on causation. And that will be some or all of the categories set out in Leader 4 as being the documents required for that purpose. And that can either be done by agreement or, if not, by an application to the judge on proper evidence. And we accept that that could happen in parallel with the Nigerian law preliminary issues. No reason why that needs...
Concurrently.
Concurrently.
Not as part of, but concurrently.
Concurrently. It's a separate stream that could run alongside. Third, and this again is in our skeleton, we do submit that the Bille claimants, the Bille individual claimants, should then plead their case on which spills caused them loss, and they should do so with the level of particularisation set out in paragraphs 94(1) to 3 of the claimant's skeleton. And Ms. Day took you through that yesterday.
(91 to 93).
94 sub 1 to sub 3.
Thank you.
And that's essentially either particular spills and inferences, facts that identify inferences of other spills, or if no particular spills, the facts relied on to identify the inferences of spills. Now, I know my lords are troubled by the question of, well, how does one do that for 2,000 claimants? And I will develop that in detail, but the short answer is, across the 2,000 claimants, there are 51 locations where they say they were caused damage. And the obvious answer is that they should plead, by reference to the 51 locations, which spills they say caused the pollution in those 51 locations. And so it's not 2,000 separate pleadings, it's 51 sections of a pleading, which the claimants would inevitably be able to adopt simply by reference to the locations of damage identified in their own statements of information.
Is there a time problem?
Is there a
Time problem. If one person is saying location A 2011 and another person is saying location A 2013.
potentially, one would have thought that the way this is going to work, and I'll come back to this, is that there will be modelling, and I would anticipate that what the experts will be saying is spill X reached an area by 2012, 2013 based on hydrology, and so a generic pleading will identify that in any event. And my own friends can't say that won't work, because their own case is that once they've got the disclosure, they can do it, because they're going to do it for individual lead claimants, before witness statements and expert reports. So on their own case, it's possible to do. Their challenge is whether it's appropriate to do it. And of course, this comes after the specific disclosure required for that purpose. And I'll develop the point, but of course, the reason we say this should be done is that all claimants' cases are tied down with some particularity before we get on to lead claims. Fourth, there should then be a CMC to decide on the future conduct of the case. That would likely take place after the Nigerian law preliminary issues, so the court would know what the shape of liability is, and the judge would, of course, also have the benefit of your judgment on amendments, and so we'll know, is illegal refining in or out, what spills are in issue. And we accept on this premise, i.e. it's not a global claim, that there will inevitably be selection of lead claims at that CMC. Whether it will be 12 lead claims selected by reference to fishing locations is a question best left for that CMC. There are obvious problems with that, not least that, for instance, it doesn't address the other main category of damage, which is harm to properties in Bille town, where the claimants lived, particularly their sources of water, which is the big complaint. And one would want to make sure that the sample claims are not simply distributed by fishing location, but also by reference to the other types of damage that are in play. But of course, this CMC, on our case, one would have the benefit of pleadings on spills to inform a better understanding of what lead claims are the most appropriate. We also accept that it would inevitably follow at this CMC that there would be directions for what's been referred to as generic disclosure. We would submit that that would be limited to the lead claims. But in any event, it would then be tied down by the pleadings, i.e. which spills are actually in issue. My fifth and final point is essentially a non-point, which is this. Further thought would need to be given to the Bille community claim. Now, my learned friend's proposal is that the Bille community claim is tried alongside the lead claims. For reasons I'll develop, that causes some difficulties, not least because the Bille community claim relates to assets, fish ponds, wells, distributed across Bille. And one can't simply say, well, we'll try the entirety of that claim. Otherwise, one is having to assess the spills across the entire 150 kilometres of Bille, which undermines the very purpose of having lead claims, that you focus on identified areas and locations. But I'll come back to that later, if I may. So the big differences between us: standard disclosure now or not. Should there be pleadings for all the claimants, as we suggest, or only for the lead claimants, with the other 2,000 odd never potentially having to particularise their cases? And potentially what should happen to the Bille community claim? Those are really the big issues of principle that divide us. And as I say, I suspect that once those are addressed, much of the underlying directions will fall into place. Now, I'm going to address each...
The last one, I don't take up time on this, but I don't recall this being mentioned at all, about how the Bille community claim should be dealt with.
It's not, and it only really...
or separately from.
It really comes up because my learned friend's draft directions, which I appreciate you haven't seen, propose a joint trial of the lead claims and the Bille community claim. And my real submission to you is that's quite difficult and will need further thought that can't be given now, and therefore is best dealt with at the CMC that I'm proposing.
Would you be prepared to contemplate that if we go along the general line that you're saying and give guidance, if we give guidance in relation to the individual claims as to which we know a little bit, that would start to create a framework or provide guidance for the managing judge to create a framework, which would then provide the context for proper consideration of how to deal with the community claims?
I accept that entirely. And without, again, wishing to descend into the detail, I can well see that the logic of a lead claims trial would potentially dictate sampling in the community claim, i.e. you choose a well in one location, a fish pond in another location, and a bit of mangrove in another location, and they become almost lead claims within the community claim.
There would be sort of lead occasions of damage.
Exactly. That would be what we would see as the logic following from it.
And you could apply the logic of lead claims to those
absolutely
damage claims,
yes.
what I'm going to call damage claims.
Yes. But what both in fairness to my learned friend and potentially in fairness to myself, that needs thought. How one would go about sampling would need thought that I don't think either side has given at this stage. But the one thing we would invite you to say, you may say, look, it's all for the managing judge, but the one thing we would certainly say is just looking at the way the community claim is pleaded, it would entirely undermine the purpose of a lead claims trial to try that as a big bang, or just to try the whole of that claim. I'm going to then address those 5 points in turn, but can I just make 3 overarching points before I do? The first is to repeat one that I made at the outset, which is the mere fact that this is not or is not to be managed as a global claim doesn't mean that the problems with the pleading disappear. We say, and you saw Lord Goldsmith took you to what Mrs. Justice Cockrell has said about the benefits of a proper pleading, and we say that those, although trite, apply in spades here. This is a massively complex claim, and experience, I would submit, suggests that the way that one makes very complex things easier is by refining them down, not by leaving them at large. It would also, we say, ensure that we can answer the claim fairly. We know what disclosure we've got to give, we know which spills we need to look at to identify defences, we know what evidence we need to gather, and we do say it would serve the useful impact, the audit function that Mrs. Justice Cockrell identified. But actually it means the claimants will have to look at, can they actually tie the loss of claimants in particular areas to anything for which we're even arguably responsible, particularly following the Nigerian law preliminary issues. And also an audit function for the defendants, that we can look at this and take a view on whether we think it has merit or not, which we can't do on the basis that it's all just about spills. I do just want to show, my lords, 3 passages in Mrs. Justice May's judgment in that context, which we say are right, irrespective of the global claims point, which is Core Bundle 1, tab 4, page 43. And this is, of course, before she goes on to decide that the consequence of these problems is that they're a global claim. In paragraph 35, the judge says she's very concerned about the current state of the pleaded case. Lord Goldsmith criticisms, which were repeated before this court, have much force. If each individual is making an events-based claim, then, as regards the vast majority of claimants, the essential element is at best sketchy and at worst missing altogether. On page 44, paragraph 38, entirely satisfied that the claimant's cases are not presently sufficiently underpinned by material which enables the necessary links to be drawn, and over the page, or over 2 pages at page 46, paragraph 43, having referred to Arch and Pride of Derby, at the end of that paragraph on page 47, in what I say is a very important 2 sentences, she says, either way, as I see it, a case needs to be made identifying the particular events relied on. Fairness requires that Shell be able to marshal a defence that is targeted to the particular events. And we obviously pray that in aid, that we say the judge was right to find. It would simply be unfair. We could not have a fair trial absent a proper identification of the events which are relied upon. And it may indeed not be controversial that the claimant's pleadings are inadequate to take this matter to trial. Their case, as I understand it, is that any case that is going to be tried needs to be better pleaded. And therefore the question may simply be one, as my Lord Justice Mayall suggested, not a question of whether the pleadings need to be improved, but when they need to be improved, and potentially for how many of the claimants they need to be improved. And my Lord Justice Mayall went on to say, well, the question is, should they be required to do it before they have all the material they say they need to do it? And our answer to that on my 5-point plan is no. They should do it after they have the specific disclosure that they say they need or persuade the court they need in order to do it. Second overarching point, my Lord Justice Stuart-Smith asked whether there was any material difference between the 4 claims for the purposes of this exercise. And I think my learned friend's answer to that was essentially no. We say that is an oversimplification. There are some important differences between Bille and Alame. In Alame, the damage is not limited to fishing, but extends to farming, farmland and fish ponds as well. So you've got different categories of damage. But more importantly, and potentially critically, the Alame claim covers a very long period. It's pleaded since, quotes, at least 1989. So we know it's at least 30 years, potentially more than that. That obviously raises its own issues. Standard disclosure over a 30-year period of everything would be an outrageously impossible exercise. And it's perhaps telling that the claimant, let me put it another way, the claimants perhaps recognise that because in their draft directions, they make no proposals for disclosure in Alame. You haven't had them.
Asked to do. We haven't even seen the pleadings. I'm not asking that we should, but
no.
Everyone agrees that the Bille claims should be dealt with first.
They do. The difficulty is on my learned friend's proposals, and it may be that this court simply says this is for the managing judge, but I just want to make sure I've answered my Lord's question, which is, are there differences? On my learned friend's proposals, although Bille comes first, their proposals provide for Alame to run in parallel, albeit a bit behind. So they want selection of lead claimants, they want evidence to be prepared while the Bille proceedings are ongoing. And all I want to draw to the court's attention is that that is something that's going to need some serious thought, because Alame has because of the time span, gives rise to some very difficult issues of its own.
I can't remember, is it 10,000 claimants for Alame?
I think it's 20,000 claimants for Alame. 11, sorry. 11, you were closer than I was, I apologise.
It's 11,000 and 2,000, 13.
Yes, I had 13,000 in mind as an overall number.
I apologise.
Don't apologise, you've given me great pleasure this morning.
Well, my Lord, I hope that long may it continue. Complicated, I should say, in Alame by the fact that in the SOIs, there is no identification of time periods to which individual claims relate. So although people say, I farmed a particular piece of farmland, they don't say when they farmed it over that 30-year period. So selection of lead claimants in Alame is going to have its own whole host of problems. But I just want to make clear that there are differences which are important.
So we shouldn't trample too heavily.
So one, I would encourage the court to think about Bille and say that Alame is a matter for the managing judge, no doubt having the same principles in mind. It's also important in my submission to keep the individual and community claims separate for the reason that I gave. I don't, again, want to trespass too far into it, but can I just show why I say they raise slightly different issues? If you have the community pleadings, which I think in your bundle, it's tab 29, I think you have that in core bundle 2. I've got it in core bundle 1, I'm not quite sure why. And if I could just ask you to go, please, to paragraph 108, which is page 533. And really just to give you an idea of what this claim is about, you see paragraph 108 is where the damage is said to have been suffered. Of course, as ever in this pleading, merely by way of example, it includes, but is not limited to. You see A, mangroves. Obviously, as your lordships will know from the maps you've seen, the mangroves cover most of the 150 kilometres of the Bille community. Aquaculture, so fish ponds, which we assume were dotted around Bille, the creek itself, the entirety of the community land, paragraph D, shrines, again, we assume were across the community. F, wells, again, something that's likely to be spread across the community. And then G, just in case those weren't generic enough, the entire environment. So when one comes to think about how one would try that, one would have to be examining the causes of pollution across the entirety of Bille. And that is, of course, the very thing I think everyone agrees can't realistically be done. That is the equivalent of the Big Bang claim of 2,000 individual claimants with people dotted all over the place. So again, that's going to need some further thought. Sampling, as I say, is perhaps the obvious answer.
What stage has the community claim reached?
It's at the same stage as all the claims, if I can put it that way, in that it's been the subject of these many CMCs. Mrs. Justice May has declared that it is a global claim, as currently pleaded, because that declaration extends to all 4 claims. And that's as far as it's got.
Right. But we're not concerned with an appeal from that declaration.
Yes.
You are.
We are.
Yes, the appeal concerns the declaration of global claims across all 4 actions.
And
the 2 individual and the 2 community. The third and final overarching point I want to make is that Malone and Friends, for understandable forensic reasons, have produced a map showing you the 12 most common fishing areas because it dovetails with their proposal for 12 lead claimants. Can I just show you, because it's going to be an overarching theme of mine, the diversity of areas we're talking about. It's in Supplemental Bundle 3, tab 50, page 790, if you can read it on top of the image itself. It's the second page of that tab.
Can you just hold on for a second?
So this is what I've been referring to as the 51 areas, although I now see that I've been flummoxed by the fact that actually the first area is area 0, so it's in fact 52 areas. But this is something the claimants have produced in conjunction with the SOIs. These are all 52 areas identified as locations of loss or harm in the SOIs where there are more than a de minimis number of claimants. I think they used a threshold of 5 claimants to exclude areas of almost complete insignificance.
So just to take, in the middle of the picture, to the
Yes.
right, there's
Yes.
a long concave or convex.
Yes.
White.
Yes.
Off-white. Does that signify that there is a claim or claims alleging loss along that stretch?
No, that will signify that the person has identified that fishing area, which has a single name, as being their location of loss. not that they've identified a spot within it.
Okay.
And that concave curve and the yellow concave curve on the left are rivers.
Yes.
Those are areas where one might anticipate that any oil spilled has flown along the river, whereas once you get within those boundaries, you are into the mangroves. And therefore, they tend to be smaller areas. But no claimant, in terms of fishing areas, I think I'm right in saying, has said, I fished at exactly this point. They said, I fished in a fishing area called X.
Yes.
So far as those rivers are concerned, presumably the pollution in those rivers is caused by every event, or contributed to by every event, which has resulted in the discharge of oil into a river upstream, whether from directly from a pipeline leak, or whether from an illegal refiner, or whatever it may be. Isn't that how it will work, at least in the case of rivers?
I can see the logic of that. I wouldn't claim to be sufficiently expert to say yes or no. But yes,
unless the quantity involved is so
very
small
small
that it has somehow dissipated and
Yes.
never gets down there.
Yes, and of course these rivers I think are tidal, so there may be slight difference with question of flow, whether they do simply flow.
There might be some of the ones downstream.
It might be some of the ones downstream, and that's why I say, but in a sense that's what we want to know, because then we know what we're dealing with. And it may well be that some of these areas give rise to different issues, which even if they have smaller numbers of claimants, would be good lead claims, because when you look at how causation is put, they give rise to a different issue of principle, which one can see that there might be extrapolation across those sorts of common types of area.
Yes, I mean, it is feasible that some of these will in fact have multiple contributing causes.
I would have thought it's almost inevitable for some of these. And some of them some of them which are very close to pipelines may not. And then again, in a sense, that's what we want to know.
Yes.
Of course, what we say is it's very unlikely that the concave area on the right was being affected by the 50 or so spills pleaded in that field 30, 40 miles to the west across two other rivers. But on the claimant's current, we rely on everything case. All those spills are in play.
This exchange demonstrates, doesn't it, that there's going to be a need for substantial expert evidence about, at the very least, migration
Yes.
and so on and so forth. And that is the area where modelling, such as was referred to on day 1 or day 2,
Yes.
comes in, where there was a, I'm sure not pious, statement that there could be or might be cooperation between the parties in modelling. But it would clearly be unsatisfactory to have, in 18 months' time, the parties to disclose their modelling over the last 18 months without having cooperated.
There having been any engagement. I see that, my lord. And one can see that there may be a case for having experts exchange methodology statements or something of that sort.
Exactly.
That's something that would need careful thought.
And
of course,
that would be even worse than counsel referring to different versions of the particulars of claim.
and it's something that I should say, just two sort of points linked to that. One is, that's not something envisaged on the claimant's directions. They simply have a big bang exchange of all expert evidence simultaneously on a single day. That is going to be a catastrophe, obviously. Secondly, rivers, of course, are closely linked to mangroves. And the point about modelling is you're not going to do modelling simply for isolated locations. Because this is a tidal area where there's going to be interactions, modelling is going to have to be done on a more global, if I can be forgiven for using that phrase, basis. Which is why we say, actually, the exercise of doing this for all the claimants is not going to be a lot more than doing it for 12 lead claimants.
Just a small point of detail. In Jala, there was a lot of talk about fingerprinting of oil. Is it thought that I'm just trying to get a handle on how complicated the expert evidence or the claims are likely to be. Do you know if that's likely to raise its head?
Let me just check. I think I know the answer, but let me just check before I say. Well, without getting into the detail, we think it's unlikely to help in this case because of the complexity of
the way things flow together.
Yes. That's not to say people won't want to try. I'm sure they will, but we think it's not likely. And I'll come back to this, but we think what's really going to happen, and in fact what the claimants were saying at one point, is the real way you work this out is you look at satellite imagery for where there is oil and oil-related damage. You look at hydrology to work out which way oil would have flowed, and then you trace back from damage to where it must have come from.
Exactly, reverse engineering.
Yeah. And I'm told by Lord Goldsmith, who will know better than I, that there was a lot of that in Jala.
There was.
Well, I should just say, if you go back one page, you will see that the 52 areas include 13, what I'm told are compounds within Bille town. So this relates not to the fishing damage, but the damage to claimants' homes, principally their sources of water.
On 790, where is Bille town?
So if you look at, do you see a sort of pinkish coloured S bend towards the middle of the? I'm going to hold it up because otherwise I'm going to make this. It's about here.
Yes.
If you see an accumulation of lots of different colours in one area,
yes,
with a red bit jutting out, that you will see matches the profile of Bille town on the previous page.
Thank you. And then, was it page 29, which was the claimant's document with the 12 areas?
It would be unagreed bundle, and 29 sounds like a realistic number. And it's not 29.
25.
25. Indeed.
Okay, and if we spend enough time, we can correlate them.
You can.
That's encouraging.
I mean, the yellow bend is probably quite a helpful, on the far left is probably quite a helpful way of tying them up, because you see the same yellow bend on each one. And we'll also, just to say that one does need to approach the 94% figure with some caution. What that means is that looking at the 12 main fishing areas would potentially guide the outcome for some part of the claims of 94% of the claimants. It does not mean that it would guide the outcome of the totality of 94% of the claimants or 94% of the value of the claims.
But that must be a matter for the managing judge.
Yes.
Of course, I mean, it seems to me, I think you almost concede, there's got to be a selection of lead cases at some stage.
There will.
And you say, and this may be true, it's not just a matter of A, B, C to L, one of each of 12 areas, one in reserve, thank you very much, next case.
Yes.
Of course, it's more complicated than that.
I do. And really, all I'm making this point to say is that given that we know this is a case about 52 areas of damage, the spectre of having to plead 2,000 separate claims is rather in terrorem rather than in practice. In practice, what there are going to be are 52 different theories of causation, all of which will derive, one expects, from a model which looks at how pollution spread across the entirety of the area. It's simply a case of lifting out of the model the spills which seem the most likely candidates for each of those areas. And obviously our overarching point is the earlier this exercise of doing the identification of spills happens, the earlier we know which spills matter, and the less time is wasted disclosing documents, investigating, producing evidence in relation to spills that actually, when people have looked at it sensibly, were so far away or so small that they've made absolutely no difference to this case. So the sooner that...
What material has already been disclosed to the claimants, and what, in relation to the spills identified in the JIV reports?
Well, I'm very happy to deal with that now if it would be helpful. That's my second point about specific disclosure. And if you're content to let me, I'd normally say I'll deal with it when it's asked. But
all right, that's fine.
Let me then quickly skip through point 1, which is the question of standard disclosure. My learned friend's position is standard disclosure across the entirety of the Bille individual claim and the Bille community claim. Now, we say no, standard disclosure comes after you've got proper pleadings in place and should be tethered to the lead claims when they are selected. So when my Lord Justice Stuart-Smith asked yesterday, and it's page 56 of the transcript if you want to see it, you asked my learned friend Ms. Day, if you were to select lead cases by reference to the prevalence of damage, that would give you, on the information you've provided, a temporal and a geographical tether for disclosure. And my learned friend's answer to you was yes. The problem is, on her actual proposals, the answer to your question is no, because she is not seeking disclosure by reference to the lead claims. She is seeking standard disclosure before identification of the lead claims and before any pleading of the lead claimants' cases. Their proposal is we get standard disclosure now without reference to lead claimants, without more particularised pleadings across the entirety of Bille for 3 years. In other words, everything relating to any potential spill anywhere in Bille at any time in the relevant period. And that we submit is impractical, unprincipled and undesirable.
It's implicit in that answer, but I'd be grateful if you'd confirm that Shell has documents relating to actual alleged or potential spills other than the 95.
We are not aware, and I can say this because we've now done the specific disclosure exercise, we are not aware of any spill that has not been reported. We have drawn the claimant's attention to the fact that there are, I think, 9 spills which are publicly reported, which they have not pleaded. But we are not aware of any further spills. And if we were, they had to be disclosed as part of the specific disclosure exercise.
They should have been disclosed as part.
They should have been, and they had to be.
Right.
And so, for instance, we had to provide reports from our incident management system, and we have, even if they were unpleaded, the judge said, doesn't matter if they're pleaded or not, you must disclose them. And so if there were any spill on our incident management system, I may have used the wrong term, that were not...
So whether by specific or standard disclosure, you are able to assure the court and, more importantly, the claimants that you do not have documents relating to other spills or alleged spills or whatever.
Yes.
And that's the position.
That is the position. What's happening with standard disclosure is that my learned friends are trying to force disclosure on fault in relation to spills that no one can identify, knows about, and may not even exist. And so, for instance, they say we need all of your security documents about patrolling the lines and things, not tied to any particular spills, because that will allow us to go and look at whether there might be, well, I don't know what it will allow them to do, but they want those categories of documents untethered to any particular spill. And we say that must be wrong. The way round must be you get the documents you need to identify the spills, which will not extend to every document on fault or potential fault. Once you know which spills are an issue, then you can have standard disclosure in relation to the spills that actually matter to something the court has to decide.
But your submission is, so far as Shell is aware, or is it has in possession its possession, custody, and control, there are no documents relating to spills other than those covered by the 95 JIVs.
I'm not sure it's 95 because, as I say, there are some that we have drawn their attention to.
Okay.
But of the spills that we have, of the already identified spills, plus I think the 9 further ones that we've drawn to the claimant's attention, we have no, Shell does not know, is not aware of any other spill in the Bille region between 2011 and 2013.
But is that using spills in a fairly strict sense? Does that confirmation of absence of documents extend to discharge of waste oil into the ground water by
Illegal refiners. No.
Well, so you're not telling us you don't have documents relating to that.
I'm not telling you that.
Yes.
I'm not telling you that.
Yes.
And,
And one would.
We don't have
Sorry.
documents. We don't have documents on criminal activity. No, because
well,
we
I mean, if it assists, I have seen a document that has been disclosed that shows that Shell know that there are spills that they're not detecting. I mean, if necessary, we can show the court, but we need to be very careful here because I've actually seen a document that shows a board report showing that there were lots of spills that are not being reported.
but in a sense, this is the point. If they're undetected, we will not have a record of them because by definition, we've not detected them. So we can't obviously disclose a record of a spill we've detected, which on Malone and Friends case is undetected.
Well, it seems obvious that the amount of oil discharged into the Bille region is far greater than the quantity of oil referred to in the 95
What one
spill.
would have thought.
And it would be amazing, to my mind, if Shell did not have documents, reports and so forth of what on earth is happening in this region. Where's the oil coming from? How's it getting there?
If there
All
were-
sorts of those documents.
Of course, and I note, I'm not sure they're actually within Leader 4 as the documents the claimants want, but that's the sort of thing that one can see. They might ask for specific disclosure of reports identifying our knowledge of the whereabouts of illegal refineries. I can see that that might be a legitimate category of request. But again, that doesn't mean you need full standard disclosure on fault. How were the pipelines designed in a different part of Bille in order to do that exercise? What needs to happen is some thought be given to what is actually genuinely required to identify spills or sources of oil.
Fault may come later.
Fault will come later.
But the first requirement for the claimants on your approach to matters
Yes.
is they must have all materials indicating the extent of spills.
Well, I'm not sure I'd say all materials. I'd say what is reasonably
You can argue
required.
about that in front of the
Yes.
managing judge.
It undoubtedly will be a question of reasonableness and proportionality. As
And as I understand the answers you're giving us, very frankly, today, there may well be documents falling within that category.
There may or may not. What I'm saying is we are willing to contemplate specific requests aimed at those sorts of documents. We will take those, consider those seriously, and if they can't be agreed, then of course the judge will have to rule on them.
And that process naturally falls before selection of lead cases
It
Does
must do.
and before any requirement for the claimants to pin their colours
Lead,
finally
yes.
to the mast.
Yes. And that's why I said it's an answer to, I think, my Lord Justice Mails's concern. Why should they have to plead before they've got documents? But we draw the line very much at stage one, what do you need to identify, spills or sources of oil? Once you then identify which of those are significant to your claim, then standard disclosure relating to those spills, fault relating to those spills may be appropriate. I should say, obviously, on things like illegal refining, there has been a huge amount already disclosed on that. Most particularly, a lot of the overflight imagery was specifically directed at the whereabouts of illegal refineries and the outputs of illegal
But it's
refineries.
for the claimants to decide whether they're going to have another pop at you to get
It
more
is.
of those sort of documents.
And either will agree, particularly if there's some sensible explanation from their expert as to why they need it, or some sensible explanation. And if we don't agree, something for the judge to decide, as she did on the last specific
Well,
disclosure.
in a way, you're right to say from their experts because it's much more potent and much less easy for you to resist if they come saying, Professor so-and-so says he can't go any further unless he has this document.
Exactly, and it's a point the judge made. She actually said in terms at the July 2024 CMC, well, you keep telling me you need more, but where is your expert who says, I've looked at the satellite imagery and it's not good enough? And that is what we say is really missing. And speaking from, if I can be forgiven from my own experience, certainly that's what one tends to see in very complex technical cases, is the expert saying, I've started the analysis, but I've reached a roadblock.
can I just pick something up with you? There's a danger of silo effect. Got to do this before you do that. Whereas the most efficient way may be for things to be happening concurrently. So you've accepted this process would happen concurrently with the procurement of. Is there something to be said? Is this feasible? Is it practicable? To identify a number of cases larger than will ultimately be selected as lead cases as candidates, so that, and adopting the normal approach, either by agreement or splitting 50-50 or whatever, however you decide to do it, so that you have X cases from which it is presently thought the lead cases will be drawn, and to start that discussion at an early stage. I can see why you say don't settle on lead cases until you've done standard disclosure and this, that and the other. But it may be an iterative process.
It may be. The danger I would suggest is that what would logically happen with selection of potential lead claimants is that we'd end up with 50 lead claimants across the 50 areas and as potential candidates, because we don't really have a way of narrowing down within an area.
But it's in both your interests to limit the number of lead cases to what is going to be most effective.
To what's going to be most useful, yes. It's a balance. Too few and it doesn't help, too many and it's too much work. I can also see, I should say, in response to my Lord Justice Stuart-Smith's question earlier, I can see that there may be a case for saying, and indeed, for saying that there should be early engagement between experts on methodology, perhaps even before the pleading exercise, not the outcome of it, but at least the methodology of hydrology and so on. I can think of, again, speaking from personal experience, in the LIBOR cases, Mr. Justice Marcus Smith ordered the experts to identify how they would go about calculating but-for LIBOR and where they agreed or disagreed before really getting into the process of doing it, so that he knew what evidence might actually be material. I can see all of that matter for the managing judge ultimately, but we suggest that this exercise of identifying spills needs to be front-loaded. That's the key point, because everything flows from that. Once we know what spills or sources of oil we're fighting about, the case becomes a lot more manageable and a lot fairer for us to defend. So, my Lord, as I say, standard disclosure we submit is impractical also, and that's even more so because we're not in the business and property court, so we're back in the old CPR Part 31 regime. We don't even have the structure of the PD 57 AD regime. And at the moment, what my learned friend is saying, having criticised the 3C trial as a roving inquiry, is that they would like standard disclosure, which is tantamount to a roving inquiry, everything that was going on in Bille during the relevant period. And if I can just show you what the judge said about that, it's Core Bundle 1, tab 15, page 268.
I'm sorry, I'm having a little bit of difficulty hearing. What was the page number?
268.
Thank you.
And it is paragraph 51. And so this is dealing with, it starts on the previous page, paragraph 48, dealing with the application for standard disclosure. And you'll see at paragraph 51, the judge refers to one of Mr. Hurler's points in favour of making progress. But it's really the 5 lines at the end of that paragraph. But as I asked Ms. Fatima during submissions, how would this work in the context of a trial where specific events of third-party interference causing loss have not been identified? Her response was she had no idea that the place to look for the identification of loss-generating events in relation to which a negligent failure to protect could be examined was the pleaded case, yet there is nothing there. And then the judge's conclusion is at paragraph 53. As I've already indicated, some sympathy with the defendant's position. While the case is presently pleaded, cannot see how fault-related disclosure can can properly and sensibly be pursued without it ending up as a wide-ranging inquiry of all activity in the region over the pleaded period, wrong both as a matter of proportionality and as a fishing exercise. And we say that was a conclusion correctly reached, whether or not this was a global claim, because the judge is fundamentally right that how can we identify which documents are relevant to whether we were protecting the pipeline without knowing which bit of the pipeline is said not to have been protected and when, unless we disclose, as is the claimant's proposal, every document relating to protection of the pipeline over the entire 3 years, covering the entire pipeline and all associated assets. And that's not a floodgates argument. Mr. Hermer was expressly asked at the July 2023 CMC, are you saying they have to disclose absolutely everything? And if I can just ask you to look in Supplemental Bundle 1, tab 13, page 272. Internal page 114, Mrs. Justice May at line 4, perhaps with some understandable degree of incredulity, is questioning whether it's really Mr. Hermer's case that they, sorry, it starts at page 113, line 23. Sorry, are you suggesting the defendant should give disclosure of absolutely everything to do with all their operations in Bille? Yes. And Mrs. Justice May, as I say, with some incredulity, says absolutely everything in relation to their operations. And if you drop down to line 11, my answer to my lady's question is absolutely yes. So their case, standard disclosure now means absolutely everything relating to all of their operations over 3 years. And that cannot be a proper or sensible way of managing these proceedings. And that attitude has followed through. We got a letter from Leader, I don't think I need to hand it up to you, but they identified what they said were 139 categories of documents, which then also had subcategories, which it was said would need to be searched, and that included everything from emails to asset registers to health and safety training to budgets to profits. It really was basically open the doors and let us come and have a poke around.
How's it going to work on your approach? Suppose that the claimants identify a number of illegal refineries upstream from the areas where they say they've suffered damage, and they say that you are responsible for discharges from those refineries because you failed to protect the pipeline, but they don't know, and they may never know, where on the pipeline the illegal refiners, or the bunkerers, whatever we call them, got hold of the oil. Because, as either you or somebody else said, we don't necessarily know. The bunkerers tap into the pipeline at some point and then take the oil off somewhere else in barges or whatever to do their illegal refining. So even if you have pleaded events, discharges from these refineries, what disclosure are you going to give which will show whether or not you sufficiently protected the pipeline against the bunkering?
Well, I'm shamelessly going to say, before answering that question demonstrates why I must be right on limb 3 of the amendment appeal, because that is the new factual issue that needs to be investigated, and it is a huge one. Again, the short answer to that is, well, we'll have to see how it's pleaded. And once we know how it is pleaded, we work out how we give disclosure in relation to it. But at the moment, there isn't any pleading at all of how they say they're going to put their case on illegal refining and the sources of oil. And that's why one needs to know, well, how are they putting it? Are they saying, actually, we infer that it came from, as has been said in the skeletons, the nearest pipeline, and therefore we just need to look at the nearest bit of pipeline? Or are they saying something different? And if they're saying something different, what is it? But again, it goes back to why you don't do standard disclosure without the pleadings. You do the pleadings and then work out what's a reasonable search for documents which will enable the court fairly to determine that pleaded case.
Your you're almost setting the stage for successive specific disclosure applications. First of all on spills, and then once they've got the spills and they've got their evidence about where the spills came from, then fault, specific disclosure on fault.
Well, I think we would accept, and I'm not ruling that out, but what I'd accept is what I was envisaging was specific disclosure on spills, followed by then standard disclosure, because once you know what the spills are, or the sources of oil are, it's sufficiently tethered to events to enable us to work out what documents we need to disclose.
Well, when you say documents relating to spills, must surely be, at a minimum, anything in Shell's possession which tends to show what the source of any spill in the region in that period may have been, whether it's a reported spill from Shell pipeline or information in their possession about spills from anybody else's pipeline, or information in their possession about bunkering or illegal refineries and so on. Because the claimants are saying, and I'm not suggesting this is fraudulent, they're saying my land or my fishing pool or whatever was polluted by oil in June 2011. I don't know what spill caused it, but you may have documents which show that it was you, or it was somebody else, or it was an illegal refinery.
Yes.
And we should know that before being forced maybe to guess as to what was responsible.
My Lord, at a level of abstraction, I accept that proposition, which is why I say we don't resist the idea that there could be specific disclosure applications. But we say that at this stage, for identifying spills, the reasonable and proportionate way of doing it is by reference to categories of documents, which indeed is the way Mr. Leader has approached it, to say in Leader 4, well, here are the categories of documents that we need, and we can debate the individual categories, but that's the right way of going about it. And not least because, as I will come to, and I promise I will come to, the evidence shows that really the way this is going to happen is by reference to imagery.
By reference to what?
Imagery. Lord, I just then want to finish standard disclosure, which I'll try and do briefly. What we do say is one has to be quite careful here that what seems to us to be happening is that rather than there being a real effort to work out how one can try this case fairly and proportionately, what is sought to be done is we identify a case in an extreme level of generality, spills in Bille over 3 years, or spills in Agale without limit of time, and then say, hand over every document you have. And whether that's by design or effect, obviously that puts an absolutely massive burden on the defendants. And it's the sort of thing that one can see is calculated to force a defendant into settlement irrespective of the merits, because it is simply such a massive exercise, 30 years for Agale, that the cost of doing it becomes excessive. Unprincipled, we say, for two reasons. First, we say as a matter of general principle, and the cases show, you plead your case properly first, then you get standard disclosure tethered to the issues which have been properly pleaded. And we say that is particularly important in group litigation, where otherwise there is a real issue with the burden placed onto the defendants by highly generic pleadings. And second, unprincipled, because we say the entire point of selecting lead cases is it reduces the burden on both sides. And there's no good reason why the burden of factual and expert evidence should be limited to the spills relevant to lead claims, but the defendants alone have to give disclosure relating to the totality of the action, even if those documents would be wholly irrelevant to the spills in issue on the lead claims. And finally, I said undesirable. Undesirable because it obviously makes sense to know which spills are an issue before we get on to fault-based disclosure. Otherwise, we potentially find that those 50 spills off in a field of their own miles away turn out to be totally irrelevant to the case when someone looks at whether the oil could actually have travelled as a matter of hydrology. But we've spent a vast amount of time disclosing all the documents relating to the design and operation of the Cawthorne Channel field in circumstances where it ultimately turns out to be relevant to absolutely nothing. So, my lords, we say standard disclosure plainly wrong at this stage. What is needed is careful focus on what is required for pleading spills. That takes me to my second point of my 5, which is specific disclosure. And as I say, whilst, as Lord Goldsmith told you yesterday, we consider the claimants could have already done a lot more to identify spills, and that there does appear to have been something of a strategic decision not to spend the money on the necessary expert analysis. We nonetheless recognise that
is that an elliptical reference to the passage we were taken to from Mr. Renshaw's witness?
Yes, it wasn't intended to be elliptical, but it was a reference to that passage.
Okay. Well, take out the word elliptical.
Yes. That they don't want to spend hundreds of thousands of pounds before there's permission for expert evidence. And I will develop that a little bit to show that we're not just exploiting that, because there obviously are things that could have been done. But leave that aside, we accept that if the claimants genuinely do need more documents to identify spills, they should have them. And as I say, to identify spills, not for the purposes of fault, which comes when we're examining who is responsible for the spills, which are the subject of the action. So what is needed to identify spills? And I hope this will finally be an answer to my Lord Justice Bean's question. Could I ask you just to take out Renshaw 7, which is Supplemental Bundle 2, tab 28, page 554. My learned friend very fairly, from the party's perspective, perhaps not so fairly from the bench's perspective, asked you to read large chunks of this as you come to prepare your judgment. And I would invite you to do so as well. But I am going to draw attention to some specific passages. But 2 introductory observations, if I can be forgiven. First, and I genuinely say this without detracting from Mr. Renshaw's considerable experience as I think he described himself a corporate accountability lawyer. He is obviously not an expert in tracing spills or the hydrology of Nigeria. And this statement does not purport to be the views of any expert. It says it's been informed by undisclosed discussions with the experts. This is not a case where Professor Bloggs is saying, I've tried and I just can't do it. And that was the point that I mentioned, and I'll just give you a reference. At the last CMC, Mrs. Justice May said, where is your expert who says, I need this in addition to the satellite imagery? If an expert came along and said, there's obviously contamination here, I need information about this, and that to do with the pipeline, then I would understand it. But all I have is you asserting that they need it. We don't need to turn up that supplemental bundle 3, tab 60, page 893. But that is a problem with this witness statement, that it is not actually the views of an expert, even if it is the views of Mr. Renshaw informed by his discussions. And secondly, there is no estimate at all about what costs would be involved. And I only say that because one point taken in the claimant's skeleton is that the exercise would be prohibitively expensive and therefore a denial of access to justice. But there is simply no evidence about the cost at all.
Has your side put in evidence of the cost which would be involved for you in getting standard disclosure?
We haven't put in the costs of standard disclosure because we take the point that it's just wrong in principle. If I can ask you to turn please to page 597. This is setting out how the claimants propose to prove their case at trial. You see that from the subheading 7. And I note that that's not the same question as what they need to plead their case. And at paragraph 115, they say it's difficult, although I note not impossible, to tie their losses to specific oil spills. But they then go on to explain how they propose to do it at trial. Paragraph 118 is important. It's anticipated that satellite imagery and remote sensing analysis will be particularly important for establishing the cause of damage to mangrove habitats in the Bille claims. And then there's reference to mangrove death. And then in paragraph 119, experts will be able to analyse satellite imagery, which will help show when changes occurred. Analysis of the imagery should enable experts to quantify the extent, locations and timing of mangrove loss. And then this will be important in determining the likely origin of the pollution and cause of damage to the mangrove habitat. And my lord, you can see why that is. If you just turn back to page 592, and this is before we've given any disclosure of satellite imagery, you have at the top of that page a satellite image from the Iconos satellite, which the claimants have obviously obtained, or their experts have obtained themselves. And if you look on the right, you can see the Sombrero River, and you can see the NCTL pipeline channel, and you see that they highlight an area of mangrove degradation in a thin yellow boundary. And then they say, well, look, that's all around the NCTL pipeline, and therefore we think that prior to May 2012, there must have been a leak from the pipeline because the mangrove around it is dying. Now, they might be right about that, might be wrong about that, but it explains why the claimants had, although they didn't plead anything based on this sort of analysis, identify where spills might have occurred inferentially from satellite imagery. And of course, I hope it's a statement of common sense that if one goes forward in time, if the mangrove destruction increases in extent, you can identify that the oil is spreading. And if one goes back in time and sees the mangrove death condensing around a point, it's likely to help you identify when and where the spill is likely to have occurred. And so one might have thought that this is exactly what would be done, or could now be done, in order to plead an inferential case that there was a spill in or around, if one could look at a sequence of satellite imagery, November 2011, in the region of this part of the pipeline.
But if the area is spreading, it might tell you that the oil is spreading, or it might tell you that there have been further leaks.
It obviously depends whether it's moving along the pipeline, or in a sense, based on hydrology, in the way one would expect from a pinpoint. That's the hydrology aspect of it. Now, my learned friend has criticised our disclosure of satellite imagery. Of course, we're not a satellite operator. The way one gets satellite imagery is either publicly, there's a certain amount like Google Earth, which is publicly available, and then there's Masses, which is commercially available. So Iconos, this image, is commercially sold by a company now called Maxar. And so it's not really, satellite imagery is not really something that we were ever going to be disclosing masses of. It's something that is available to both parties. What we have been able to...
It would be relevant that you had the images at a certain time.
It may be, and we've disclosed the ones we have, but my learned friend's complaint that we don't have many is, in my submission, neither here nor there. Obviously, a very important source that one uses, and one saw Mr. Boyne's reference to correlating sources, multiple sources, if I can put it that way, is overflight imagery. And we've disclosed tens of thousands of overflight images. So these are helicopters or planes that fly over the region and take either videos or photos. And one can see, I'll give you a reference, I don't think we need to go there, but there's an example of one of these photos in Supplemental Bundle 2, tab 33, page 658, where one sees oil sheen on water and one sees mangrove death, both of those around an illegal refinery. But overflight images are another very important way of identifying contemporaneous evidence of where oil was located. And as I say, we have disclosed a mass of such images. And one would have thought, based on Mr. Renshaw's own evidence, that what one would now be doing was taking those images, both overflight and satellite, looking at where mangrove death had occurred, and attempting to identify inferentially where spills had occurred. That links with what Mr. Renshaw says at paragraph 121, that you combine satellite imaging with hydrology. And
where's this going? You are accepting in principle that there may be scope for a specific disclosure act.
Yes.
What more do we need to know?
It really goes to answer my Lord Justice Stuart-Smith's, my Lord Justice Bean's question, which is what do they have? What have they already been given? And it sets the context of what I say is there really doesn't need to be wide-ranging standard disclosure in relation to identifying spills, because the core material, even on the claimant's case, is available to them or disclosed.
Well, that's right. What's the problem? I don't understand this. If you have documents in your possession relating to actual or alleged spills in the region, whether from Shell pipelines or from any other source, I can't at the moment see why those are not plainly disclosable. And the fact that there may be vast quantities of satellite images available to anyone or which you've already disclosed, so what?
Well, my Lord, ultimately it's a question of what is reasonable and proportionate for the claimants to be able to present their case. Yeah. And if they have the 25 categories which are almost certainly sufficient to enable them to do that, why should we trawl at vast expense through, for instance, emails to ask, well, has anyone happened to mention a spill in an email, which is a vastly expensive exercise?
We haven't got any information about the overall value either of the Bille individual claims or of any of the four pieces of litigation, either as asserted by the claimants or as downgraded by your particular perspective. I think the only thing we know is we were given a figure of £7 million for the process of preparing
the SOIs.
And I think that's for the 13,000 rather than just for the two.
I think that's right.
These are very large sums of money. Proportionality is very difficult for us to take any view on proportionality. From where I'm sitting, this is an enormous piece of four enormous pieces of litigation involving very substantial investments of expenditure just as costs, inevitably, where no proportionality arguments on the basis of outcome has been or could be advanced.
And just to add to that, there is also a claim for an injunction to make you clean everything up,
yes,
which, if it were to be ordered, would presumably involve vast expense.
It would. I mean, one can imagine there are very real difficulties with ordering us to clean up land we don't own.
In another jurisdiction.
Or indeed have any right to access, and which is subject to huge amounts of militant action. But I nonetheless take the point. Nonetheless, I do say that the court doesn't simply throw its hands up and say it's a big piece of litigation and therefore every stone has to be turned over. One still starts from the premise of asking, what do the claimants actually need? And that primarily is a question for the claimants to justify. I would say primarily by reference to what their experts say they need to do the analysis. And so in my submission, the right way round is to say, well, what have the claimants justified for this particular purpose? Bearing in mind standard disclosure we accept will come down the road. What do they need just for the purposes of pleading their case properly? And in my submission, when one looks even at how Mr. Renshaw explains how it's going to be done, which is satellite imagery and hydrology, one does have to exercise some real doubt about whether or not wide-ranging additional disclosure is required. And it may be that is
the second appeal is an appeal from two declarations made by the judge. Ms. Day and her team are asking us to allow the appeal, set aside the declarations. I don't think they're asking us to conduct a CMC today, which we're not qualified to do, and we may, as you said, one possibility is we give some general indications of our views on case management topics. We might or might not do that, but we're not being asked to make orders for how many lead claimants should be chosen, what further disclosure ought to take place, if any, before the selection of lead claimants and so on.
I accept that, my lord. I think Ms. Day, and I apologise if I get this wrong, I think she does intend to ask you to say standard disclosure at large is the appropriate next step. And that is the position in their skeleton argument, certainly. And that's the only reason I'm addressing this. And it may be that it's sufficient for you to say, if you are minded to give some guidance on the shape of the litigation, that you don't think standard disclosure across the board is appropriate, including fault. You do see the force of the argument, as I accept, that they need documents to be able to identify spills and sources of oil, and it's a matter for the managing judge whether that's done by reference to further specific disclosure or whatever else it may be. I just make two very brief final points by reference to this statement, and then I will move on. On page 594, and I promise I won't labour these points because I appreciate what my lords have said. Paragraph 107 is dealing with undetected leaks, and I just want to draw attention to what's said in the middle of that paragraph. I understand that monitoring pressure is not an adequate method to detect such leaks and would be unlikely to detect ongoing underground leaks of this nature because their release rate is likely to be low. Instead, these slow leaks may only be detected, if they're detected at all, when oil reaches the surface, which again is another point I would say that indicates that actually, again, what is going to be critical to identifying even alleged undetected leaks, it is imagery that identifies whether oil has reached the surface. And finally, if I could just ask you to turn to paragraph 1 through 37. The claimants there identify what they say will be disclosure relevant to causation, and most of these categories, in fact, all of them bar one, then formed part of the specific disclosure application. The one that didn't is paragraph 142, which is the pipeline pressure and production monitoring data. So a lot of what the claimants themselves were saying they really needed to deal with causation then formed part of their specific disclosure application. And I do just want to show my lords that briefly. Supplemental Bundle 2, tab 19, page 369.
369.
369. You will see at paragraph 74, Cs apply for specific disclosure of Roman 1 documents which Cs and their experts require in order to make efficient progress towards identifying which spills cause damage to which Cs, with a view to addressing the concerns which the court has expressed about the current state of the pleading. So this was all about what do the claimants say they need to make progress in identifying spills and causation, which was the defect that the court had identified. On page 373, the fourth point, the claimants accept that they were seeking a substantial number of documents, as indeed they were, and indeed they received. And then one sees the sort of things that were being requested at page 374, records of specific spill incidents, 375, assessment of impacts of spills, those sort of spill impact maps which have been disclosed. Page 376, aerial images, and you will see at subparagraph 2 Aerial and satellite imagery was said to be of critical importance to assess the location and scale of oil spills, chart the damage in which areas they occurred, and therefore was said to be critically important to this. And then there was, for instance, over the page 377, asset integrity and maintenance records. And the judge ordered, to the extent it wasn't agreed, the vast majority of that for both pleaded and unpleaded spills. And I'll just show your lordships where the order is for that. That's Core Bundle 1, tab 14, page 242. And you will see paragraph 5, reports. A is reports for significant incidents. B is minutes of meetings which refer to pollution. Various other documents. E is loss of primary containment reports. F is environmental evaluation studies, and you will see we disclosed a major independent exercise that was conducted when we disposed of the pipelines that assessed the environment at the time. Over the page, I, remediation action plans. J, contamination monitoring data. K, spill impact maps. L, annual asset integrity status reports. M, well maintenance records that may indicate an escape of oil. So there wasn't a fault, non-fault division here. If they were fault documents that could be related to fault, but could also indicate a spill, they had to be disclosed. And then NO and P are imagery. And those were indeed all disclosed, mostly between February and April of this year. I know my own friend made some points about the number of documents that have been disclosed. Those in my submission are rather misguided. My own friend said, for instance, we've only disclosed 3 annual asset integrity reports. Well, the obvious answer to that is each of those reports runs to hundreds of pages. There are only 3 years in scope, so one would only expect 3 annual integrity reports. She said we'd only disclose 95 spill impact maps. Well, given we're only aware of that sort of order of spills, one wouldn't expect lots more spill impact maps. But we have disclosed what the claimants themselves said were the key documents to enable their experts to get on with this analysis. And we do say, although I accept it's not a matter for your lordships, that the managing judge, as Mrs. Justice May did say at the July CMC, would be entitled to say, if there is a request for more documents, well, you've had a lot that you said you needed, where have your experts got to? And are they saying they can't do it without a whole load more? So what we say needs to happen now is that sort of analysis to be done with the experts, look at the documents they've got, look at the satellite imagery, and identify what else they really need. Obviously, you've had Mr. Leader's fourth witness statement that identifies what they say are the further categories they would need. Some of that, I think my own friend accepted, looked a bit difficult, like leak detection systems, when it's common ground there weren't leak detection systems. Some of that has already been disclosed. So, for instance, it includes spill impact maps. And we've produced a table, it's at page 82 of the unagreed bundle, which sets out the extent to which we've already disclosed what's in fact been asked for. And we do have some doubts, at least without a cogent explanation, about the utility of some of the documents being sought, for instance, pipeline design documents. We are really quite sceptical that one could reverse engineer where a spill occurred from the design of the pipeline. Now, if an engineer is saying that that's something that could seriously be done, it may be different. But at the moment, it does look to us like a bit of a fishing expedition. But on this point too, what we say is, we know what needs to be done. The claimants get the documents they reasonably require to plead spills, and that is what should happen, either by agreement or by the managing judge making what orders are necessary to achieve that. Point 3 is then the pleading of spills and causation. So we say, after the claimants have had the documents that they say they need, or the court concludes they need, to plead spills, then that is what they should do. Whereas And we say they should do that by reference to the 52 areas of damage rather than simply for 12 lead claimants. I should say that the difference may not actually be as large as it looks, in that if one chooses 12 lead claimants, they may well live in 12 different areas in Bille, in which case we're going to have another 12 areas in play, and they may well fish at 1 or 2 areas that are not in the top 12, as we saw from the SOIs. Those individuals fished at 1 or 2 locations that are not the top 12 areas. Now, if you're getting to the point where your lead claims actually implicate 30 or 40 of the 52 areas, I do ask, what is the sense of only pleading out the case for the lead claimant? If it's going to be done effectively for 40 areas, let's do it for the 52, bite the bullet, and have a properly particularised case across the board going into the exercise of selecting lead claimants. And we do say that is our proposal, that there is a proper pleading across the board, is right in principle, and more appropriate than the claimant's proposal, which is effectively to defer indefinitely the need for 2,000 odd claimants to plead their case properly, because you only plead the 12 lead claims. And I say that for a number of reasons. First, the claimants cannot say that they won't be able to do it. They themselves propose pleading spills and causation, albeit only for the 12 lead claims, before getting to factual statements and expert reports. So they accept they can plead spills and causation with particularity after they have the documents necessary to do it. Second, and I'm not going to...
And behind the scenes, they will have to crank up their expert evidence to give them the answer.
They will. And I say no bad thing.
Yeah. So time will have to be built in for that.
It will, but again, front-loading that is beneficial, because then we can be getting on with investigating the spills that matter. Whereas at the moment, the idea that we're going to investigate hundreds of spills over 3 years without any knowledge that they're actually going to matter in the end is, in my submission, pretty unrealistic. Second, and I'm not going to repeat what my learned friend Lord Goldsmith said, but we say that is what the rules and authorities require.
That would be to repeat what your learned friend Lord Goldsmith said.
Exactly, and so I will simply say that's my second point. Can I do just want to pick up something that my Lord Justice Stuart-Smith asked me about, I think, on Monday, and it's been something that's been turning over in my mind, which is, should one modify pleading requirements where the case is of this complexity? And I'm not going to repeat what my learned friend said about the authorities. All I would say is this. The basic pleading requirements have stood the test of time because they work. They ensure that there can be a fair and efficient trial. And the risk of shortcuts, like most shortcuts, is that actually, although they seem attractive at the time, they end up causing confusion and uncertainty down the road. One also has to be quite cautious about unintended consequences. If one relaxes pleading requirements, it will, for instance, have a knock-on impact on, say, concealment, because the concealment test for limitation depends on the statement of claim test. Can you plead the facts to start your claim? If the court says, well, you can start your claim with virtually no facts, you're actually forcing claimants to start their cases earlier because they risk not being able to rely on concealment on the basis that they meet the statement of claim test because they can just plead something very generic. And finally, although we can see that there may be some case for deferring, forcing a party to plead its case fully until it's had the disclosure it needs, and one sees that in competition cases, you can plead a cartel saying, I don't know how it happened, but I will tell you after disclosure. That is not a basis for saying most claimants never have to plead their case properly. Maybe a basis for deferring it, the when question, but it's not a basis for saying it doesn't need to be done at all. So that was my second point. My third point as to why you should order a pleading across the board is that we say that that will ensure that the parties and the court get the most juice, if I can put it that way, out of the lead claims trial. And I'll give 3 brief sub-reasons for that, which I'll call A, B, and C. A, knowing which spills all the claimants rely on will assist in identifying the most appropriate lead claims. It may be, for example, that the claimants in 3 fishing areas that are all very close together rely on the same spills, and therefore having 3 lead claims in those 3 areas isn't actually terribly useful. It might be that you say actually the 13th and 14th largest fishing areas are more appropriate because that's going to test a different...
Hang on, are you suggesting that every one of the claimants should identify the spills that they rely on?
Well, if there's
you get to a selection of lead cases?
If there is a pleading by reference to the 51 areas, that will de facto have achieved that. Because for all but a trivial number of claimants, they rely on harm caused in the 51 areas. And a person who fishes in area 50 is not going to have an individual case on causation. They're going to be saying, well, I rely on the spills that polluted area 50. And so if you have the stages that I suggest, disclosure to identify spills, a pleading that identifies the spills relied on for each of the 50 areas, then one can select lead claims in the knowledge of which spills are relied on for each area. And you can then choose claimants in areas that best cover the spills. And when I say best cover the spills, I mean individual spills, because you may be able to say, well, look, one spill is common to a number of areas, and therefore we want one area that definitely looks at that spill, but also that identifies issues of principle, because you may say, well, look, that area raises a question about pipelines which have failed by corrosion, which is not going to be picked up by lead claimants in other areas. And actually, it's useful to know we'd like an area that is going to investigate pipes that have failed due to corrosion, because then we'll be able to extrapolate that to other areas where a claimant is relying on a spill caused by corrosion. And that's, in a sense, the point made by...
That is a huge undertaking.
It is a large undertaking, but it's substantially the same undertaking as the claimants accept they are going to have to do on their proposal once lead claims are identified. If you have 12 lead claimants, potentially covering 30 or 40 different areas, they've got to do it straight after identification of lead claims anyway. So the question is, do you do 30 or 40 areas immediately after selection of lead claims, or 52 areas before, with all the benefits that brings in terms of tying claimants down, most appropriate selection of claimants? It's not a problem that's going to go away.
On that map of the 52 areas, I didn't think I was colourblind, but I find the colour coding quite difficult. Is there somewhere in the metadata a link that one can cross-check? Because certainly on what I've got, I was clicking all over the place, but I couldn't find something which said of a squiggle, this is number 32.
It's the claimant's document, so I suspect they may be able to provide you something more helpful. It's actually all tied to GPS coordinates, so I'm sure they do have a document that is perhaps more user-friendly in electronic form, if your lordship would like that. I'm promising things that I don't have any control over, so, but I suspect that that's something that claimants do have, and that's simply a flat PDF of it. Point B is that having that pleading provides the best chance of extrapolation and therefore a settlement or resolution following the lead claims trial. Because on the claimant's proposal, the most we're going to really be able to do is extrapolate in relation to the areas which are the subject of the lead claims trial, other claimants who fished in the same area. On our proposal, we will know all the spills that the other claimants are relying on, so we'll be much better placed to extrapolate, either because the very same spill is relied upon in a different area, or because the same type of spill is relied upon in a different area, a corrosion spill or a TPI spill. Point C is that we say that having the pleading would minimise the risk of what we've called evasion or pivot. Now, I entirely recognise, I think my Lord Lord Justice Mayles and my Lord Lord Justice Stuart-Smith both made the point that that is a risk in group litigation, that particularly factual issues, you may well not have res judicata that formally binds across claims. and can formally prevent the issue of relitigation. But I do submit that one mitigates that risk by having the claimants tie down their cases before you get to the lead claims trial, because we are very concerned at the moment that if we have a lead claims trial and it doesn't go well for the claimant, what will happen is that claimants who fished in the next fishing area along will say, oh, well, that's not the spill I was relying on, I'm going to try a different spill. Is that realistically going to happen? I don't know. But when the claimants have invested such a large amount of money, one would have thought that they're not simply going to accept a loss lying down, and that they are going to want to put themselves in the best position to salvage whatever settlement they can extract after a bad result.
Well, that applies both ways.
It does, absolutely. It hurts us as much as it hurts the claimants, in that if they've done brilliantly at the lead claims trial, we are going to find ourselves in a position where we know that they are saying the same spills are relied upon for X different claimants. And that's why, I accept in different contexts, but in the securities litigation, the courts have been so keen to say, tie down your cases before we get to lead claims, because then we can make sure we've got the relevant, best, most representative lead claims, and they will extrapolate. And that is a very useful and important discipline in group litigation, in my submission. Otherwise, one is really just hoping that both parties will accept the same extrapolation post lead claims trial, and that this case is a particular risk of that. I accept there are similar issues in other cases, but where you have 100 different events spread out over a massive area, there is obviously a much greater risk of pivot than there was in, for instance, Bodo or Jala, where you have essentially one or two spills, and there just isn't the opportunity to do that. The reality is, liability is a common issue across the claimants, and therefore any lead claims are likely really to determine liability. Causation and quantum may be a different issue. So we do say very, very significant benefits to having a pleading across all the claimants by reference to the 52 areas before we get into lead claims trial. It's not impossible, and in fact it's not a lot extra work compared to what the claimants themselves are proposing, which is likely to require them to do this for 30 or 40 areas. And in reality, this is going to be done by producing a model, a hydrology model, mapping spills onto it, and is going to be capable of being extrapolated to different areas, rather than there having to be a completely separate exercise for each of the 52 areas. Point 4, we then suggest that the next stage should be a CMC to select lead claims and give directions down to trial. We say that that's the right time to do it because on our submissions, we'll then have your Lordship's judgment on amendments, and therefore we'll know whether illegal refining and which spills are potentially in play. We'll have the Nigerian law preliminary issues judgment, which will have a fundamental impact on what needs to be tried and what facts are relevant. And on our proposal...
You can't get to the stage before the preliminary issues trial.
I mean, in reality, the preliminary issues trial is February. We're not going to get...
There's no way you're going to get...
Yes.
Where is the order or agenda for the preliminary issues trial?
I think it was handed up to you.
Yes, you gave us the preliminary issues.
Yes, I think my learned friend handed you... It's about 20
Came in
pages.
as a loose document held together by a paperclip.
It did.
But with whole bunch.
It was not from my side, so I can be as rude as I like about it.
Preliminary issues statement of assumed facts.
It is. There is also an order, which you should probably have, but that is the issues and the various permutations of assumed facts on which they're to be tried.
It's fine. In light of the court's comments and the fact that the defendant doesn't agree our order, I'm not going to press the detailed order.
I think they're asking for the preliminary issues order. They're asking for
the preliminary issues. Sorry. Yeah. Yes. We should have that somewhere. I think that was handed up already.
Yes.
Yeah, we've got that somewhere.
Yeah. There is an order that goes with it. I don't know if your lordships want that. That essentially says these will be tried. No.
Yeah.
But we recognise, as I say, at CMC at that stage, the court's going to select lead claims. Whether it's 12, whether it's more, how they're selected, I'm not sure it's a question that your lordships need to be too troubled by today. We obviously say that would be best informed by having the pleading. And as I say, we also recognise that there would be directions for disclosure at that CMC relating to liability and fault for any spills or sources of oil that were an issue on the lead claims. But that, at that stage, would be standard disclosure tethered both by geography and time, in that we would know what sources of spills we're talking about, maybe broader, maybe narrower, depending on illegal refining, including whether illegal refining is in as a matter of Nigerian law and or your lordship's amendment judgment. But at least the standard disclosure would be tethered to the events that the court is going to be trying. Point 5, you'll be pleased to know the final point of the 5-point plan. It is just a comment on the Bille community claims. I don't really need to say anything more than that, other than
Don't forget it.
they need thought. It needs thought. It certainly isn't capable of being dealt with in the way my learned friends suggest, that we just try the Bille community claims as a whole without any further particularisation. We have no idea which spills are relied upon as having caused what damage across the Bille community. We suggest that's best dealt with at CMC. So, my lords, those are my submissions on what you should do if you conclude that the claims are not global claims. Just before I sit down, can I address 3 points briefly? 2 of them are, I think, homework that I was set after the amendment appeal. The first was the question from my Lord Justice Stuart-Smith about whether there was really an issue to do with the foreseeability of illegal refining. And I said I'd check and come back to you. Position slightly different for Bille and Agale. Agale concerns pipelines and infrastructure that were built many, many years ago. And in fact, the defendants had ceased to operate in that area by 1993 because of the security situation. And we have previously served evidence that the infrastructure in Agale was largely built at a time when the environment was benign. So there certainly will be a question in Agale as to whether we could have foreseen illegal refining, certainly on the scale that it ultimately occurred when we constructed that infrastructure back in the 1980s or whenever it was. Second, for Bille, our pleaded case is that illegal refining has proliferated since 2009. That's paragraph 11 of the Bille individual defence. And Mr. Boyne has given evidence that the reason for that proliferation was that there was a government amnesty with militants in 2009, and that many of those militants then switched from sabotage into illegal refining. That's Boyne 3, paragraph 46, which is Supplemental Bundle 2, tab 24, page 479. So again, and I'm not saying, I don't want to say I'm right or wrong about this, but there certainly will be an issue if illegal refining is in play about whether we could have foreseen the scale of the problem of illegal refining when we were designing and constructing the pipeline in 2006, 2007. The second question from my Lord Justice Mayles was whether one can obtain pre-action disclosure where jurisdiction is in issue. And I wonder if I could just hand you up an extract from Matthews and Malik on the question. I accept it may ultimately not prove to be the most significant point in the appeal. But if I hand...
Does it tell us whether the answer is yes or no?
It tells you that the answer is... Oh, sorry. Sorry. It tells you 2 things. If you have... so obviously it deals with the 2 types of pre-action disclosure, Norwich Pharmacal and Rule 3116. At paragraph 308, it tells you in the first couple of sentences that Norwich Pharmacal relief can be given in aid of foreign proceedings or contemplated foreign proceedings. So jurisdiction certainly wouldn't be an answer to a Norwich Pharmacal application, but obviously whether the sort of information you were missing for your pleading was a Norwich Pharmacal type issue is a different question. In terms of pre-action disclosure, at 336, one sees the requirements for pre-action disclosure, and so the respondent's got to be likely to be a party, applicant has to need to be a party, the documents need to be within the scope of standard disclosure, and disclosure needs to be desirable in order to, for instance, dispose fairly of the anticipated proceedings, which we would say it obviously would if you needed it to plead a case and avoid limitation. And then 339 deals with the question about jurisdiction. It recognises that it is implicit in requirement C, because of the reference to standard disclosure, that this is only disclosure in aid of English proceedings. But you'll see it then goes on about halfway down the paragraph, where there is more than one possible jurisdiction for the substantive proceedings. So long as it's contemplated that proceedings may well be brought within the jurisdiction, then it may be said that that is sufficient. The fact that they're outside the jurisdiction doesn't matter. And then this, even where a respondent claims a substantive claim would not be justiciable in the English court, or that England is not an appropriate forum, the court may order pre-action disclosure. A respondent would need to show a really strong prospect of success in the court declining jurisdiction in the potential claim before the court would decline to make pre-action disclosure on that ground. So a case of doubtful jurisdiction would still support an application for pre-action disclosure. The last point for me to touch on is that my learned friends handed you, I think 24 hours after you directed it, but nonetheless have handed you their note on publicly available information. I don't take any issue with the timing, not least because a sensible approach has been taken. There's no new factual evidence. There is a concession that 31 or 37 of the spills were on SPDC's website, although they say 6 of those were the ones they pleaded. And they take the position that this isn't relevant, and they're not going to tell you why they weren't pleaded because it's privilege, and I can't go behind that. It could have been carelessness, it could have been a deliberate strategy. We certainly don't know. What is apparent, though, is that the claimants cannot say to you that these are all spills that they could not have pleaded. They say it's not relevant because we're not challenging discretion. I accept that. But insofar as my learned friend is pressing a case that you have to relax the pleading requirements because they couldn't plead more, they cannot make good that proposition. In terms of NOSDRA, they say they don't accept the inference that they were on the NOSDRA website. That's a matter for your lordships. We say the basis we've given is a sufficient basis. And of course, given that my learned friends must now accept that they didn't properly examine the Shell website, they're not in a position, obviously, to say that there weren't other spills on the NOSDRA website, which they presumably also failed to investigate properly.
Forgive me, but what do you say this goes to now?
We say it goes to any argument that the claimant should be held to a lesser degree of essential facts in their pleading when it comes to the limitation analysis, as my lord put to me, because of the difficulties of pleading a case in this type of situation. What my learned friend can't say to you is, you have to allow us not to have pleaded essential facts because we couldn't have found them, because we know for at least 31 to 37 of the spills that they could have found them. Obviously, this doesn't relate to illegal refining, which everyone knew about and was not pleaded for unexplained and inexplicable reasons. The only point I want to make on NOSDRA is it's suggested to undermine our inference at paragraph 5.3 A, that our point that we reported the spills to NOSDRA in line with its regulatory obligations is only made in the present tense, and therefore it doesn't follow that we had reported these spills to NOSDRA contemporaneously. Of course, that's a bad point, because my learned friends have the JIV reports, which show when they were reported to NOSDRA because they attended the joint investigation, and they can see that they are all contemporaneous. So you can certainly proceed on the basis that all the spills had been reported to NOSDRA contemporaneously. The missing piece of the puzzle is whether NOSDRA had put them up on their website. We say you should infer they had. They say you shouldn't draw that inference. We both accept that neither of us can put forward positive evidence one way or the other. Unless I can assist. Assuming I have assisted, unless I can assist any further, I have at least kept my word and finished by 5-2.
You've been very helpful. We'll rise till 2:15.
Rise at table.